Hello, this is Attorney Pendergraft, and this video is on the eviction process in Maryland from start to finish. And you can download the slides to this presentation at tpf.legal/eviction-process. Disclaimer: this is legal information, not legal advice. For legal information, contact an experienced landlord-tenant attorney in your jurisdiction. Step 0. Determining the correct cause of action. There are 4 ways to start an eviction proceeding in Maryland. You can file for failure to pay rent, which is used to evict non-paying tenants. Tenant holding over, which is used to evict tenants that refuse to leave after a lease expires. Breach of lease, which is used to evict tenants that have substantially breached the lease. And wrongful detainer, that is used to evict non-tenants or squatters. These are people that are, and they are often family members. For more in-depth explanations on each cause of action, check out these posts and videos. And here you can see those links. If you want to learn more about failure to pay rent or all of the other causes of action, check out those links where I talk more in depth on what is required to prevail in that particular cause of action. Step 1. Mailing a notice, if required. In most jurisdictions in Maryland, the landlord is required to mail a notice before commencing eviction proceedings for tenant holding over and for breach of lease actions. Most jurisdictions do not require a notice for failure to pay rent hearings or for wrongful detainer hearings, but check with your local district court to be sure. Step 2. Filing complaint in the local district court where the property is located. The next step is for the landlord to file a lawsuit at the local district court where the property is located. The landlord is required to pay a fee to the court to file the complaint and a fee to serve the complaint. Depending on what the cause of action is that the landlord filed for or that particular court's custom, she may be given a court date on the spot or she may be mailed a court date. Step 3. Sheriff service of process. The sheriff then visits the property to serve a copy of the complaint. If they cannot serve the tenant personally, they will post a copy of the notice on the door. After the tenant has been served, she can respond by filing a defense in court or waiting until the court date to defend herself. This is also a good time to contact an attorney if the tenant needs one. A common defense that a tenant asserts is rent escrow. Step 4. The merits hearing. At the court date, the landlord presents her case and the tenant is given an opportunity to respond. The judge then makes a decision after hearing both sides. If the tenant does not show up, a default judgment will be entered in favor of the landlord. Step 5. Filing the warrant for restitution. If the landlord prevails, the next step is to file a warrant for restitution for the return of the property. With the exception of failure to pay rent, the warrant for restitution can be filed immediately after the landlord gets a judgment for possession. A landlord must wait 4 business days before filing a warrant for restitution for failure to pay rent. There is a fee to file a warrant for restitution. Tenant's right of redemption for failure to pay rent cases only. Generally, tenants have the right to stop an eviction by paying the landlord the amount owed on the judgment, and the landlord must accept the payment. Tenants that frequently do not pay on time can lose the right to redemption. Tenants can check the order to see whether or not they have the right to redemption. The appeals period. For failure to pay rent cases, a tenant can file an appeal within 4 business days of the date a judgment is entered. In all other actions for possession, a tenant may file an appeal within 10 calendar days. Filing for an appeal does not automatically stop an eviction. In order to do so, a tenant must pay an appeal bond. Step 6. The eviction. In most jurisdictions, the sheriff will contact the landlord to schedule an eviction date after they receive the warrant for restitution. The sheriff will instruct the landlord to bring a locksmith and a number of people that they need to bring, along with trash bags. It is the landlord's responsibility to hire an eviction crew. Generally, the tenants are not given the eviction date. However, in Baltimore City, a landlord is required to give tenant notice of the eviction date. On the eviction date, the sheriff and your eviction crew will show up at the property at the appointed time. The eviction teams will throw out the tenant's possessions and change the locks. Need a landlord-tenant attorney? Do not hesitate to contact me, Brian Pendergraft, at info@tpf.legal. That's preferred, or you can give me a call at 301-205-9013, or you can find me on Instagram at Pendergraft Firm. Unable to afford an attorney? Check out my do-it-yourself legal kits. The kits contain sample complaints, defenses, and arguments based on real documents and arguments that I've used to prevail in landlord-tenant court. For landlords, I have the Maryland Landlord Eviction Self-Help Legal Kit, which can be found at tpf.legal/landlord/kit. And for tenants, I have the Maryland Tenant Rights Self-Help Legal Kit, which can be found at tpf.legal/tenant kit. Thanks for watching, and you can download the slides to this presentation at tpf.legal/eviction process.